Hello, good morning from Thailand. This is MD Omar Farooq from AIT Extension, welcoming everyone for today's webinar on Security of Payment Act for a construction project practice in Western Australia and Thailand perspective. This webinar is designed to benefit the construction project stakeholder by knowledge sharing session on Payment Act. Today, we have three expert speakers from academia and practitioners. All of them will enlighten their discussion in the context of Construction Procurement Act practice in Western Australia and a proposed bill for Thailand. Let me brief you about today's session plan. We have two parts. First half on solo presentation from three keynote speakers and second half on panel discussion followed by question and answer. The second part of panel discussion and question and answer session will be moderated by our Executive Director of AIT Extension. Throughout the session, if you have any questions or concern, please feel free to write in the Q&A section or chat box. We will address your point during the Q&A session. Without any further delay, may I now invite our Executive Director, Mr. Vorabet Chongla-sen, to welcome our global audience. Over to you, sir.
Thank you, Mr. Farooq. Thank you very much. And good morning, good afternoon, maybe good evening to some of our audience here. On behalf of AIT Extensions at the Asian Institute of Technologies, I would like to welcome you all to these webinars on Securities of Payments Act for the construction projects, which is today AIT Extension wants to bring in the experience from the Southern Australia and also comparisons of the perspective in Thailand on the current perspective in Thailand on the regulation and also legislative related to construction contracts management. So we have selected these subjects for today because number one is that AIT also offering a master degree and PhD program in infrastructure engineering and management. And in this field of study at the School of Engineering and Technologies of AIT, one of the subjects that professional and student has to study is related to the construction law and construction regulation, which is very important. The second reason is that because of the rapid growing in construction industries in the regions, in the Southeast Asian regions and also in the Southern region and other regions, we need a lot of instruments and regulation and legislative that can, help us to be able to sustain the construction industries and make the construction is very fast. So that key stakeholder and key actors will be very happy about that, and also the business of the construction industries and also the practice can be sustained for the long term, and also the benefits will be going to the people, going to the countries, and also going to the global societies. So we are very glad, we are very honored that we bring in practitioners, Mr. Neil Kirkpatrick, who has a lot of experience, practical experience as the arbitrators and also adjudicators in the construction industries, and he himself works on the regulation and legislative in Southern Australia, which we will hear from him and also learn from him. We also have Dr. Nopon Lee Prishanon from Thammasat University, teaching in Faculty of Engineering, who are very much interested on the research related to the construction contracts, commercial contracts, that application to the regulation and legislation in Thai construction industries and also other places in the region. We also have, senior practitioners, senior professionals, Mr. Shamnan Pichetpan, who is, the chairperson, the representative from the Thai Construction Law Association, who has a lot of field experience and also interactions with the government parties, with the contractor parties, with the private organizations and academicians to help the organization to have the instruments that can facilitate and can also enable the construction industry to be more, suitable. We have Dr. Narong and we have others, Mr. Farooq and Mr. Karim here, helping me to address some of the questions that maybe I'm not able to do that. So this is going to be a kind of a very semi-formal session where we allow the audience to raise a lot of interesting questions and ask a lot of concerns on the practical point of view and also on the technical point of views. So thank you very much for joining us today. We are looking forward to interacting with you more with different sessions and online sessions from AIT Extensions. And I wish you enjoy these sessions that we are going to organize in the next few seconds. Thank you.
Thank you, sir, for your valuable message. Maybe I will share the screen now. Okay, now we are starting our first part of solo presentation. At this stage, I would like to introduce our first presenter, Mr. Neil Kirkpatrick. Neil Kirkpatrick is from Australian construction industry. Mr. Neil is the Managing Director of Construction Expert Service based in Sydney, Australia. He is a highly experienced chartered quantity surveyor and chartered construction manager, arbitrator, adjudicator from New South Wales, Australia, Queensland, Western Australia, and Northern Territory. He has over 25 years of experience assisting clients, consultant, development companies, and constructor in solving construction project-related problems. Beside this, Mr. Neil's educational background includes BSc Honours, Master of Law, Diploma in International Commercial Arbitration, DIP ICARB, FCIARB, FRI, FRICS, FCIOB. Dear participants, let us now hear from Mr. Kirkpatrick. Over to you, sir.
Thank you very much, and Swaddy Cap to everybody in attendance today. And thank you to AIT for the invitation to speak on this subject. Today, it's a very important subject for the construction industry, and it's commendable that a group have got together to organize and raise interest and awareness about this with the hope of introducing legislation. So, as the introduction said, I am based predominantly in Australia, and I'm an adjudicator in a number of states. So as Australia is a federation, each state has its own legislation, and that has really evolved over the last 24 years. The first piece of legislation came in on the East Coast in New South Wales in 1999. And then after that, each subsequent state introduced its own legislation thereafter up to last year, 2022, when West Australia introduced a new act, and it really is now the act to follow in Australia. So the question really, why focus on Western Australia as not just the whole of Australia? Well, each state tends to do reviews from time to time, and Western Australia has brought in an act that really mirrors the East Coast model and has probably the most contemporaneous thinking inside that act for the country. So what is really the object of security of payment? And that can be really summarized very concisely under the West Australian Act. It is written into the legislation, and it says under Section 3 that the object of the Act is to provide a efficient and fair process of securing payments to persons who undertake to carry out construction work or to supply related goods and services to the building and construction industry. So in effect, what it is to reform payment behavior in construction industry. And that's about what we call practice of developers and contractors delaying payments to subcontractors and suppliers. Because when you don't have cash flow in the construction industry, delays can occur and projects can really come off the rails quite quickly. So there's been quite a body of case law built up over the over 20 years in the whole of Australia. And under the legislation then has evolved through the different case law and the different opinions that come out. And in effect, what has been established is that the legislation itself it's not concerned with finally and conclusively determining any entitlements of the parties. So that's an important aspect of security of payment. It's really an interim, an in-between step where one party who believes it is entitled to be paid a certain amount of money can use the legislation in a quick and efficient way to get money flowing from one party to the other. But what is significant about the legislation is that it isn't intended to be a final and binding determination from an arbitrator, say, where the decision is just final. So it just provides cash flow, and effectively the parties can fight another day as to who is actually right or wrong. Now, in the legislation, there are certain contracts that are allowed and certain contracts that aren't. So the issue really that the legislation needs to grapple with is what is construction work, and what is the really, how broad do you define the industry, and what sorts of contracts are to be captured really by the legislation. So these are all questions that the legislation itself has to answer, and why the legislation tends to be quite long in parts. And what sorts of industry can you capture and can't? For example, if you take construction work at its highest level, that includes everything to do with a building at all. The question then arises, what sort of industries would benefit from this legislation, and what sort of industries use construction work to progress their own particular parts of that industry or that particular thing? So, for example, home building itself, should the legislation apply to home building? Because you have to understand that whilst you look at the legislation from the point of view of, say, a contractor seeking money, and initially you think, well, that contractor was badly treated. Well, maybe you have the reciprocal situation where a contractor was seeking to be paid money that it potentially wasn't necessarily entitled to in full. And if you have people that are building a home and they don't understand legislation like this, they can get into a terrible mess. So in respect of home building, for example, in West Australia, anything under $500,000 is simply not included in the Act. So that's the sort of thing. The Act doesn't apply to other things like employment contracts, loan agreements, contracts where there's no money involved, so there's no payment involved in anything like that. But other than that, there's a very broad definition of what is included in construction work and related goods and services. Now, the point is really, what does the Act intend to do, and how does it actually get money to flow from one party to the next? And what it does in effect is it sets up a secondary scheme, a statutory entitlement to payment. So you have your construction contract, and then the legislation is interrelated with that contract, such that there is a separate right of payment under the Act as well as under your contract. And what the Act does is it seeks to use the contract where terms exist, but where terms do not exist, it then sets out minimum standards of what the parties must apply. For example, a contractor is entitled to one payment a month. And if a contract does not say when that payment claim must be made, then it becomes simply automatically at the end of the month under the statutory regime. So the legislation is very powerful in that way, and you cannot contract out of the legislation. So parties try to write all sorts of things into their contracts, but the legislation overrides unfair terms. And also it's evolved now in West Australia to having voidable time bars, and it protects claimants against threatening and intimidating behavior, such that there are fines of up to $50,000 where parties maybe don't behave particularly well. but it also confers immunity on the decision makers, such as myself as an adjudicator, and it can introduce approved forms for certain things like payment claims and payment schedules. So these are all very powerful pieces of the legislation that really set out and try to protect the parties to a contract under construction work. And even if there isn't a contract in writing, it applies to an oral agreement, and therein lies the issue that can be quite difficult sometimes for adjudicators to determine. But where there are no terms, the Act then itself sets out minimum sort of terms that could be applied. So it also sets up a building commission who then administer the legislation. So the government has a department that administer adjudicators such as myself. We have to register and train and be of a certain standard. And it sets up what's known as authorized nominating authorities. And these are the organizations that the government uses for parties to a dispute to apply to have a payment dispute determined, and they manage the application process. So that's the sort of arrangement in general terms. And in effect, I think certainly the one aspect of the Australian legislation now, all around Australia, not just in West Australia, is that we have a system of statutory entitlements that sits alongside construction contracts. So it's not just the construction contract that you turn to, you also look at how that fits inside the legislation. And that's a very important part of this sort of legislation. And it then becomes a very powerful protection mechanism for the parties to a contract to make sure that money can flow through the industry and people get paid and projects can move forward without having disputes run on for a long, long time. So we also then have, with the evolution of these legislations in Australia, retention trust schemes. And that's a sort of different aspect of security of payment as opposed to just receiving payment from a payment claim. But what the acts do now is they set up a requirement for a certain sort of size of contractor and project that they must put retention money in a trust, a managed trust, and they're not allowed to use that money in trust for any other purpose than for retention. And that trust is administered and reviewed, and there's an audit of that trust done, and all of the retention money put into those trusts for different projects. Because one of the problems about cash flow is not just while a project is progressing. One of the big problems in the industry can often be that a contractor may go out of business and may have used retention money to finance its own operations elsewhere. So this was a particularly difficult problem, and how that has been addressed is by including a retention trust scheme under this legislation as well. So that's really a summary in 10 or so minutes. I think probably enough to start the presentation off with, and I'll hand on to the next speaker.
Thank you, Mr. Nail, for your very nice and informative presentation. We will be hearing more from you during the panel discussion session. Before I invite our next presenter from one of the leading universities in Thailand, I would like to introduce a bit about him. Associate Professor Nobborn Liptichanon recently drafted the Security of Payment Act for the construction industry in Thailand's context. He has been with the Faculty of Engineering, Thammasat University, since 1996. With his long-standing involvement with the Thammasat University, he was also engaged in different important positions, such as the head of the Department of Electrical and Computer Engineering, President of the Faculty Senate, Advisor to the President of Thailand Science Research and Innovation, TSRI, and many more. Besides this, Professor Nobborn's educational background includes PhD from RMIT, Australia, Master of Engineering from King Mongkut Institute of Technology, Thailand, LLM and LLB in Business Law, Master of Accounting, Master of Arts in Politics and Government, Bachelor of Engineering. In a nutshell, he has earned 7 degrees in 4 areas: engineering, politics, law, and accounting. Also, he is an arbitrator in Thailand. With this, dear participant, let us now hear from Dr. Nobon. Over to you, sir.
Right. Thank you for the introductions. First of all, I would like to start my motivation with some of the international practices where I have learned from many countries, mostly from the Commonwealth countries like Singapore, Australia, and also Malaysia as well. So those countries practices all the security of payment that would be the great idea that Thailand would have this kind of law to secure the payments of the contractor and to carry out the construction work as well, where there are a lot of complexity of the payment issues occur. And why does Thailand need these security payments laws for construction industry? Due to my motivation on the cash flow problem that I have learned from my friends, a lot of people have a lot of problem with the cash flow problem, which play the important roles in the construction industry supply chain and the related circular economy. Of course, that would have the very big problem when people would have a problem with and have the impact on the in theory with the entire ecosystem of the construction industry. And the problems like this cannot be really solved by current legal system in Thailand due to, of course, some of the long-term process, and it's costly as well. So the idea of the security of payments law, which is very good choice, which can have already proven and successful in many countries as well. So this law, when we reviewed it, is established legal mechanisms for the contractor that's exercise the right to make the payment claim from the employer. So once the contractor have fulfilled the terms of the contracts and to promote the systematic settlements of the disputes over payments of the construction contract and respondents to the need for speeding up of the payment process as well. So these kind of things have the nomination so the institution in the law can nominate adjudicator with the necessary skills and experiences, and the adjudication process in this country is quite cheaper and really faster than the arbitrations and court. So under the concept of the payment, when you work for someone, the payments must be made, right? Course, so the workers are entitled to be paid for the work they have done. This is a principle. So the contractor have right to get the payments where they have the duty to deliver the good work for the owner of the project. Why the owner of the projects have right to receive the complete construction service, and they also have the duty to pay as well. So under this, when we talk about dispute, mostly in Thailand, they go to arbitrations or the court. But actually, for the payment issue only, it may be not necessary to go for the arbitration or court. They may start from negotiation, like they may arrange the amicable settlement, make it easy to talk if they can do it. But if not, maybe if they can step into the mediation process where they got some other people to talk with both parties. But if it's not successful, so before going to the arbitration, so the idea of adjudications will be the good choice. But this is to be said that it's maybe not good for the complexities issues, but for the payment issue only, I think it would be great. So the principal aims of the adjudication, so it's to improve the payment process and to improve the cash flow problem, and to provide the default payment mechanisms, expedite the solution, and make the recovery of the payment effective. Definitely, yes. The purpose of the law should come to force on the followings. The first is to facilitate the regular and timely payment, and to prohibit the conditional payment term. For example, like pay if paid, pay when paid, and back to back. This is the common practice for the main contractor when they when they have the excuse to the subcontractor, they just have this kind of execution. And this to facilitate also the speedy for the dispute resolution through the adjudication, to be sure that the payment is promptly made. And this is cheaper than application in court, as I said, and this can remedies for the recovery of the payment too. And sometimes if we make a good arrangement, there is no need to have a lawyer in most cases, unless the case is large and complex. You can make it through the laws mechanisms that maybe if just only very simple case, the lawyer maybe not may not be needed. And of course, the principle is on the fast track process, the rough justice, pay first, argue later, and this can elevate cash flow, and this kind of law is a temporarily binding only, but until we go through the arbitration and the legal action. The impacts of this law to the consultants, there are good impacts, and that we can think about this if we would like to have this kind of thing of law in Thailand. So for the consultants, the lawyer, they have the opportunity for adjudication support work and to become adjudicator themselves. And for the lawyers, they would have the opportunity to have the consequence litigation works too, like a liability for defaults, possible claims for breach in contracts and negligence. And for the construction professionals, the impact on them would be the positive one, that they, of course, the need to improving the professionalism and good practice too. So to be sure that they can deliver good work and get the payment from the owner without execution. And the need to get the protections and indemnity or P&I insurance, so maybe come to the picture if these laws is enforced. And the opportunity to become an adjudicator, and for the contractor or for the construction professional, it can be possible and can do the adjudication support work too. But for the adjudicators themselves, under the law, so that would have the opportunity to the people who becomes adjudicator. So they need to maintain the competency, integrity, and professionalism if the adjudicator comes from the construction professional or come from the lawyer or any person who interested in this job. And of course, these people have to be sure that they need to maintain themselves as a statutory immunity against any actions as provided acting in good faith too. And the impact on the construction industry as a whole and the contracting parties. So the pro sides that we can see is that they change the payment culture and allows more distributions or allocation of the payment risk to the ecosystem. And this can reduce unfair practices of the constricting cash flow to improve the quality of work and professionalism too. And this minimizes the payment disputes from going to arbitrations or actions, legal actions when it's necessary. For the employer or the project owner, they would change the attitude towards the payment issues for them, and would enforce the fair allocations or distribution of risk, despite a dominant position, and improve professional and good governance in settling the payments from the owner side. And it would be like the case or reduce the bad habits of the employer, of course, because if they can see that, so the law can enforce them in the future. And the law, the impact is another impact is it can obtain the improved quality of work and the finished product from the contractor itself. If this law it enforces the contractor mostly, they have to deliver the finished work products to exchange with the payment settlement. On the contractor side, so this allows the receipts of the regular and timely payment for them, and to improve the cash flow and speedy resolution of the payment dispute, and make it cheaper cost and through the adjudication rather than going to the arbitration court. And that allows a statutory recovery of the payments after adjudication, and for the employer in regard to their obligations to their subcontractors. And for the subcontractor in general, as a whole, that would be the same as the contractor side. But in addition, it allows enforcement of the payments in the absence of express provisions in the subcontract, and develop this professional body of the downstream supplies or subcontracts effectively, and this can support the upstream players of party as well. Based on the law in Thailand, we are now drafting a bill. So I and the group of the people led by Dr. Narong and Ajahn Chamnan and the Society of the Construction Law. We help and also the THAC as well. I mean the THAC is the Thailand's Arbitration Institute. So we think about drafting this kind of bill so that we can have this law in Thailand. So the scope of the bills are roughly this apply to the constructions with the written form, and this executed, of course, in the Thailand territory, or whole part or some part of that must be in Thailand. And this does not apply to a certain type of construction contracts as required by law. And the outline is in the law. In the second group is on ADR issues. So we use the adjudicators concepts, right, for the dispute resolution. But we can reserve the right to sue in the court, or can enter into the arbitration process, so that if they step into the court and arbitration process, so this process of adjudication can have to be sustained, or it cannot be enforced. So the first one is the condition for entering the adjudication process. So the claimants must submit the complete claim form, and then they have to state the amount of the payment, due date, and the related contractual costs. And the adjudication process starts if the respondent fails to make the payment within the deadline. And this we have the faster adjudication. The law will state the faster adjudication by setting up some certain date and day. The decision-making process would be quicker than the court, and the arbitration at a whole, it would be about maybe 30 plus 30, about 30 days plus some things. So this is under discussion. We still need to be sure that on the constraint on the process in Thailand can be relaxed. And for the revocations of the adjudication decision, so this is a shorter process for revocation of the adjudication decision than application. If the respondents that are happy with that decision, they can apply for setting aside, or they too. But for the criminals, they can also get this one to apply to enforce in the court too. So the enforcement also can have the warrant of option, like going to the court and can get a certificate as a warrant to enforce a lawsuit in court, and calling to the guarantor to pay for debt on his behalf, for example. I showed this maybe timeline process. Maybe it's in general practice, like in another country. So when both have the dispute, so the claimant we make the payment, claim for work or good service or variation to the institutes, and the respondents will make a payment schedule. So which in some day maybe 10 business day or 15 days, something like that. So if the Kremlin is not happy of that, for example, like respondents will not pay for by the payment schedule or pays not some part of that. So the Kremlin can apply for adjudication process to the institutes, and the institutes organize determines and nominates an adjudicator to proceed this one. And the institute will send a notice paper to the respondents. So after that, the adjudication will work on the review of the case. The duration of the process would take about maybe 30 days altogether, or plus. So this is under the discussion. And the consequence of the adjudicator decisions can be two ways. Once, if the respondent doesn't happy with this decision, of course, they would have reason and that would meet the requirement upon the conditions set by law. So they can apply for setting aside to the court, and they can submit the document to the court by 15 days, subject to the condition in accordance with the act. And this is a kind of the partial revocations. And this is not cause, but it did not cause a remission of the case. But for the enforcement, the Kremlin's request for the certification for 90 days, and they can call for the guarantor to pay the debts instead. And maybe another way to apply is to suspension of construction contract operations, but not more than 30 days. So this is one of the way to enforce to the respondent to pay for that. And for some countries, they apply some kind of concept like a lien concept. They can retain the property or goods or some kind of that with them until the owners will pay the settlement. So this is the idea and the view of myself that I have learned and discussed with the many people in the industry. And this law, this bill have proceeded for about maybe almost 2 years. So go with the THAC, we have the public hearing in Thai version for 2 times, and after that we have some discussion, a meeting with the group of the construction lawyer society, led by Dr. Noro and Dr. Shamnan, and we have some discussion, and this group take the draft to improve the draft. And right now the draft is under review to be sure that we can hand it into the parliaments maybe after the elections this year, if possible. This is our expectation. Okay, thank you very much for your attention.
Thank you, sir. Thank you, Dr. Nobon, for your very nice and informative presentation. We will be hearing more from you during the panel discussion session as well. Now, I would like to give a little brief about our next presenter, Mr. Chamnan Pitchapon. Ajahn Chamnan is presently serving as the senior legal advisor and attorney for Thailand. He is the member of Criminal Court Revision Committee, Office of the Council of State, consultant for the Consulting Engineering Association of Thailand, guest speaker on construction contract and construction management. In the past, he also served as member of the board of the Government Pharmaceuticals Organization, vice chairman in the Thai Health Promotion Foundation Committee, Thai Health, member of the Public Health System Research Institute, HSRI Committee, legal advisor and construction project manager of BIOC Building 1 and 2, chairman of the Construction Expedition Committee in Thai Health Promotion Foundation Committee, Thai Health. Beside this, Mr. Chamnan's educational background includes Barrister at Law from London in 1979 and Bachelor of Law from Thammasat University in 1972. With this, dear participant, let us now hear from Mr. Chamnan Pitchitpan. Over to you, sir.
Thank you, Mr. Farooq, and thank you to AIT Extension to organize this webinar. I think the subject is very important. Since I have been dealing with construction law and construction contract, even construction litigation for 40, 50 years already, the problem has been non-payment, mostly from the employers. And then you have to go to court. And the court take long time because the court have so many cases and very limited number of judges. And then it's caused the contractor sometimes bankrupt. They don't have money. 2 years ago, Dr. Nopon initiated the idea of drafting the law on security of payment, and then sponsored by arbitration center. We call THAC. This arbitration center set up by Arbitration Act BE 2550 10 years ago, 13 years ago. This is an institution under supervision of Ministry of Justice. So the law initiated by Dr. Napon has proper channel to go to parliament, not a private law. That very difficult to get to parliament and get through the parliament. But this law, I believe that we have a good possibility of getting this draft become law in near future, like Dr. Napon said. Now, why do we need this law? Since I have been dealing with the construction contract many times, many years, and I have experienced a lot on litigation to enforce payment, we try to draft the contract to enforce payment effectively without success. We look at the international standard, international contract like FIDIC, like other standard international contract, NEC, AIA, whatever. They try to impose a condition on heavy interest. They call it financing charge. They try many conditions in the contract. But still, the problem remains. The money remains unpaid after due. After I have been getting involved with this draft by talking to Dr. Nopon. Our team of construction lawyer society study a lot on various acts of many countries like Australia, Singapore, Malaysia, United Kingdom, and few other countries. We understand that they also have problems. They cannot get condition in the contract for payment effectively. That's why they have to have the law enforcing the payment. Now, how this law can enforce payment? Do we have to go to court again? If we go to court, delay again, problem remain unsolved. Mostly the law set up, this law set up an organization to manage the problem about payment quickly, effectively, and fairly also. How do they set up an organization. They set up administrative entity and something like judicial make a person making decision. Now, person making decision, they call it adjudicator, who would decide whether the payment should be made. And then they have administrative body. Some create new one, some use the existing arbitration institute, or some use the professional council like architect council of that particular country. So now the law would have one part is administrative body. Second part is the person who make decision. They call it adjudicator. Now, adjudicator would be appointed by mutual agreement of the party. If mutual agreement of the party cannot obtain, then the law would say that the institute that organize the administrative function would appoint the arbitrator. Now, you see, we get somebody by the law to make decision who is not the judge, who is not the arbitrator. Why? Because they want to get the decision done quickly. Now, decision involving what? The law said only non-payment of construction industry. We wonder also why only construction industry. Maybe I think Thailand have same problem with other countries that have this kind of law, because construction industry tend to pay late, and construction industry tend to have big amount. Now, if big amount is paid late, the payee suffer, because you see in construction business, you may have main contractor, you may have subcontractor, subcontractor, and then you have labor. If the main contractor do not get paid, what happened to subcontractor? The cash flow problem. When the main contractor get cash flow problem, on the rest got problem down to labor, and that caused a lot of problem on the economic of the country, and also the person who is receiving end of the money, they suffer. Also affect the construction period, and that also bring the dispute matter. So I think this law is very good, and do agree with Professor Napon that we should have this law in Thailand. So after talking to Dr. Napon, we set up a committee of learned professionals of related field to help looking into the draft of Dr. Napon and suggest whether any particular section should be amended and how. And finally, we got 15% headed by Professor Nalong Leung Butnak, who is chairman of this committee. So the content I'm going to talk briefly would be the decision of the committee, not my personal view. Now, after we have we agree, we set up the organization similar to those law in other country, but the administrative body, we think that the arbitration institute in Thailand should handle the administrative work. We have many arbitration institute, but we limit to arbitration institute belong to the government, like the office of the judiciary arbitration institute and the TSAC arbitration institute that set up by law would handle administrative work. We have adjudicator appointed by the party, disputing party, and in failing to reach mutual agreement, then the head of the arbitration institute would appoint the arbitrator. Now, in some case, in the case of where the dispute, the non-payment arise, some laws say that the person entitled to payment have to serve a notice to the other party, telling him first that if you don't pay me within certain period of time, say 5 days, I will go to this arbitrator, I will go to this adjudicator and take action against you. This matter we have been discussed whether it's good idea in Thailand, because it might be threatening to the employer first, and then relationship goes out. Why not, when the contract provide for payment, say within 30 days after it become due, you just go to the adjudicator, file a claim, and then proceed. I think I'm more than 10 minutes already, but I try to short the period for the adjudicator to make the decision based on document only, would not more than 15 days. But for other case that you have to hear witness, not more than 30 days. Payment period must be within 30 days after receiving decision of the adjudicator, failing which the payee entitled to do many things like go to court, ask the court to enforce payment. The adjudicator can award interest up to 15%, because if the interest is high, it push for earlier payment because already decided. The adjudicator can make injunction, undisputed invoice can pay first. Say the contractor claim for 10 million, the employer argue that you are entitled to only 8 million, so 8 million pay first, 2 million argue later, something like this. And some provision of the contract we have similar to those in the law of other country, like a provision to say that pay when paid is void, ineffective. In Thailand, I think we have practice similar to other country. Main contractor would have the contract with subcontractor that if the main contractor receive payment from the employer in relation to the work done by the subcontractor, only then the main contractor will make payment to the subcontractor. And this problem go to the court already, Supreme Court of Thailand. In one case, there was a problem that main contractor and employer contract has been terminated. And then main contractor would never have any opportunity to get the payment from the employer. Then the subcontractor cannot get paid because the main contractor never received that sum. The Supreme Court said that provision become null and void because it is impossible. So the main contractor. So you see that the problem arises so many things. Then we also say if the employer do not pay after the adjudicator make decision, then they can go to the employer above him. What we call is head contractor, similar to the labor. If the employer do not pay, they claim up until the main contractor. But here, if the main contractor do not pay, or the head contractor do not pay, then we go up until the employer. We can enforce the payment. Now, since this law related to contract of the construction industry only, we wonder what kind of contract, construction contract, or then we have many other contracts related to construction. Construction is direct, you constructing some works is construction contract. How about cleaning? Some other laws include cleaning of the work, construction work. So we include some laws say that the service provider related to construction also include like designer, construction supervision, the consultant in construction business. So this one include. Now, how about supplier of construction material? Other laws should include. We include also, but we did not include one thing: the construction contract where private natural person is employer contracting to build private house for use, not for sale or hire, with no more than 1,000 square meter, and the height should not be more than 10 meters, something. Because what we think is not be a fair dealing between a private person and the business person. They are sitting, they are not equal. We see that other countries also exclude this, like Mr. Neil said. So our draft also similarly provides. So I think I can go this far because it's already beyond my time limit.
Yes, sir.
But we can discuss later.
Later on, yes, sir.
Discussion question. Yes.
Yes, sir. We have time. We will discuss more in the panel discussion as well. Thank you, Achan Chamnan, for your very nice and very informative presentation. We will be hearing more from you during the panel discussion session as well. Distinguished participants, we will now move to our second half of this webinar, which is panel discussion and question and answer session. At this stage, I would like to invite two more guests, Mr. Fazle Karim and Dr. Narong, to join this next session. Dear audience, Engineer Fazle Karim is the Director of EIT Extension. Let me show you one more slide. Mr. Fazlikar is the director of EIT Extension. He have a very diverse background and he is one of the most senior person for us. And Dr. Narong, he is the adjunct faculty in the School of Engineering of Asian Institute of Technology, AIT. With this, I would like to request our Executive Director, Mr. Horavet Chonla Sen, to moderate the panel discussion and Q&A session. Over to you, Achan Horavet. Sir.
Thank you, sir. Thank you, Mr. Farouk. I think the better way to do the discussion is to continue the conversations. Before we are coming to the Q&A sessions, which I now saw two questions in the chat box, which I will raise to the panelists. I would like to maybe request Neil and Dr. Nopont and Khun Chamnan to give a final key message regarding the topics in terms of the security of payments before we are coming to the panel discussion. So Neil, would like to say something for 3 minutes, final message?
Chanman raised an interesting point about the notice that a party might give to the non-paying party under a contract before they apply for adjudication. There's two ways to look at that notice, because what you have under the statutory regime, remember, is a procedure that is established between the parties, that it's not just the contract that you're considering, it's the legislation that overrides a contract in places. So that it's really the concept of how the law itself would sit either within a contract or outside the contract and be interrelated. So the act in West Australia that was introduced in 2004, the old act, as it's known now, effectively supplemented the contract, and it introduced implied terms into a contract where the contract had unfair terms. The new legislation has brought West Australia into line with the rest of the country, where it now supplements the contract with a separate right to payment. And the interesting thing about the second chance notice, as it's called, the notice that you give to a party before you go to adjudication, is that in that statutory legislation that overrides a contract effectively, if a party does not respond to a payment claim, then the payment claim in itself is the party that's claiming payment is entitled to the entire payment claim unadjusted. So that's the reason for having a second chance notice. And really it sits inside the legislation in the way that that fits in industry. I don't think a second chance notice is really needed where the legislation supplements a contract and you look at the contract terms that are resolved in dispute. I actually thought the old act in West Australia was a very good one. It was relatively simple. You looked at the contract itself. You didn't need all of the different procedures under the legislation. You looked at the terms of the contract, and if the contract didn't have terms, the legislation then set out terms that you implied into that contract itself. But the contract itself was always what the adjudicator referred to. Now that still is the same in legislation that has a separate right, but there's an interrelationship. It's a slightly more complicated arrangement where that separate right to payment exists under legislation in addition to what the contract says. So that's the reason for the second chance notice. And it's really there to help a respondent party that has allegedly not paid a payment claim either in its entirety or in part, to that hasn't issued a payment schedule, to really be put on notice to say, look, if you don't pay, we're going to go to adjudication. And if we go to adjudication, you're going to be entitled to pay the full amount of this payment claim. So if you reverse the sort of power between the parties there, and what if a contractor claims an unfair amount under a payment claim, and then a respondent doesn't receive the payment claim or doesn't respond to it in time, and there are several variations that were really unfairly claimed, or the valuations were based on what the contractor thought it should be paid, but they, for argument's sake, were simply unfair and very inflated valuations. So that in itself is quite an unfair set of circumstances for a respondent or an employer to have to pay. And one of the reasons why the second chance notice is there. And if an employer doesn't respond to a payment claim the second time, then one might say they really deserve to pay the unfair amount, and then they can go off and argue that in its finality another day through arbitration or another dispute resolution mechanism. So that really comes back to the sort of concept of what the legislation is, and really the two types of legislation that have been used in Australia for the last 20 years. One supplements the contract, and the adjudicator just turns to the contract itself. And the second legislation is one that sort of overrides it and provides that separate statutory right to a payment claim. And that sets up a separate system effectively. And it's quite interesting as to how countries then, choose which option really to go with. One final point on that is on the separate sort of entitlement, the statutory right. What does evolve or seem to evolve is very complex payment claims and payment schedules, because under the legislation, a party who's responding to a payment claim has to include all of their reasons why they don't wish to pay. And in relatively large projects, they can be very large documents, and that is a difficulty for contractors and an administrative burden, I think, that's probably unintended in the legislation. So there are many, many different aspects to consider when introducing the law. And one of the reasons I think why the old Act in West Australia had a number of benefits that may be now superseded through the new Act that was brought in August last year.
Thank you, Neil. You already addressed one of the questions that raised by one of the audience, Mr. Thanapat, already in relation to the legislation on the West Coast and also the East Coast. So thank you very much. Next, may I request Dr. Nophon to give some key message after the discussion in the early stage. Dr. Nophon.
So I thank you very much for the good arrangement, and I would like to deliver some message to the people who involved in this industry, that this law, I think it's very important, as Neil and Ajahn Chamnan has mentioned. In Thailand, we have many people suffer from the process of the payment issues in the construction industry, where they pay when the works are very hard, especially on the subcontractor worker. But many times, many occasions, they don't have the payments settled by the owner of the project because of some kind of like a payment paid back to back condition like that. Which is becomes the bad conditions and the consequence to them. If this law can be passed through the parliament in the future, that would leverage the quality of life of many people in the industry. So, but to do that, we need a lot of support from many stakeholders, because making the law in Thailand is not easy, because there are a lot of political parties involved. There are a lot of stakeholders involved. So we need very strong support, not only from the academic side, but on the business side, on the community side, and especially for the groups of the people who have the direct impact to this situation. So this law would involve a lot with the construction industry, including contractor, consultants, lawyers, architecture, engineers, and academics. So as I said in the slide, there are a lot of opportunity if this kind of law can be launched. The new work will come like educator, professionalisms, and we can have the good direction for the owner to have the payment culture, the better payment culture, like for example. So my key message is I would like to invite all the stakeholders who can see the strength and the advantage of this law, come with me and Dr. Chamnan and Dr. Long and the group of the structural lawyer and all the sponsors to drive this law to be possible as soon as possible. Without the cooperation of you, it's not be possible to make it in Thailand. So this is the key message I would like to deliver. Thank you very much.
Okay, let me ask Professor Narong his view. I mean, after hearing all these messages from our colleagues over there, and after that we come back to Mr. Shamnan. So Professor Narong, please, from the viewpoint of the construction engineers and also academicians, what is your view on this?
Thank you, Mr. Chairman. I also need to learn from Australia, from Mr. Lim. One thing that very important for the application of act, this act cannot apply to any contract for the carrying out of construction work in some conditions, such as the residential project or personal housing. So because for personal housing, the employer is the people that they may not familiar with the kind of law, something like this, to be fair for them, both contractor and the employer also. The second question that I like to learn from you, Mr. Neil, regarding the subcontractor also. So how many level of subcontractor that this act should apply to be fair for every level of this kind of subcontractor? Thank you, Mr. Chairman.
Thank you, Professor Narong. Neil, you would like to address that? Neil?
Well, that's a good question, because if you think, I mean, what do you include and what don't you include in general terms? So in the acts in Australia, they exclude certain types of residential building, but they also exclude mineral resourcing, but not all of that. So non-process resource type work is included, and there's always a line that is a bit complicated as to, so what happens is the industry evolves and contractors have a go at an adjudication, and maybe an adjudicator said this isn't included, it's excluded work effectively. That case may go to court, and then a court would issue a decision, and they may say, look, the adjudicator was right or the adjudicator was wrong. And over time, you get a more defined view of what is and is not construction work, in inverted commas, in the defined term. But in residential work, recently in New South Wales, so we take on the East Coast, they have opened up the act to include residential work over a certain limit. And one of the reasons why they did that, and this actually answers your second question as well, is if you're a contractor building a dwelling, a house for a private client, that is excluded from adjudication, from the legislation. Say that's excluded work. Well, it's not excluded work for the subcontractor to take the contractor of that project to adjudication. So if the plumber didn't get paid, or say the contractor procured plumbing work on a dwelling and the employer did not pay the contractor for that plumbing work, then the contractor didn't pay the subcontractor plumber for that work that was complete. Well, the subcontractor can still take the contractor to adjudication under that arrangement, but the contractor couldn't take the employer to adjudication. So there was a fundamental issue about cash flow with because of the excluded work. So excluded work only applied to an employer and a contractor and not down the chain. And therein lay the problem, that if you don't address the industry in its entirety, there is an issue with cash flow flowing through the industry. So that's one aspect in excluded work. I think it really should be included. I think most domestic should be over a certain value. I think having a limit on value is sensible. But when you think about some housing projects, they can be quite complicated buildings in themselves, potentially more complicated than an office project. So why shouldn't they be included with quite sophisticated clients? Now, in respect of fairness for different subcontractors or different entities in the industry, the Act sets up a payment regime so that if a contractor makes a claim against a principal or an employer, there's a certain time limit to be that payment must be made, and that is a slightly longer time limit when applied to a contractor and a subcontractor. So there is that sort of tiered approach. The legislation has considered the different timings because obviously a contractor needs some amount of time for administration to make payments out that it has received in. But the legislation as a whole should apply to everybody in the chain down to a point. So there are carve-outs for things like employment contracts. I mean, it obviously couldn't apply to a labor contract, an employment contract, but it applies to labor contracts in labor hire, a skilled labor hire where you have a commercial company that provides labor, as it were. So they're the sorts of arrangements that they have, and I mean, it's just where do you draw the line with excluded work? Once you start excluding certain types of work, then you introduce some complexity, and because you've got to define what construction work is, and there are certain industries that just, I suppose, lobby to, and maybe that sort of a payment, the security of payment regime doesn't really suit things like mining industries and direct resourcing and maybe some power industries, but they're very narrowly focused now. So Australia has really narrowed in on what it means by, mineral resourcing, and it's the actual extraction activities on the whole. But that evolves over time with different case law as the industry progresses and industries change and new industries come in, and there's an abundance of renewable energy now and renewable energy projects all around Australia, and these sorts of industries have had to have been considered in the legislation, and they're applicable or not, just depending on the sort of industry that we're talking about. So.
Sure, yeah. I mean, yeah. So it seems that it has to also to develop the registrations according to different industries. But the whole thing should be addressed throughout the whole value chains of the service of the construction industries. Khun Chamnant, would you like to address the key issues, especially in relations to the adoptions of these new legislations that we are trying to do? What is the critical important for this stage for the Thai construction industry?
Thank you very much. I think critical important now is that actually Dr. Napon's draft, also our committee's draft, give some necessary information for the government to proceed already. So this draft go to Ministry of Justice. Ministry of Justice may amend a little bit, then go to the government, go to government, the cabinet. Cabinet would refer to Council of State. I've been sitting in one of the committee of the Council of State for 23 years already. I know it takes long time. They amend a lot. So what we draft, even though we think it's perfect, would never be perfect. But actually, we give them idea what we want. Then when the draft go to the Council of State, they might summon us to give them some understanding, someone other related authority to give them the opinion. Then they come up with a draft. It would go back to the cabinet. The cabinet would refer to Parliament for review. Process might take 10 years, or even longer, or even never become law at all. Now, I think why this draft go to Ministry of Justice, go to Cabinet, go to Council of State, we can proceed with what Dr. Nopon suggests. We can communicate with political party, other interested party. Now it's for your benefit. Please give each other a hand and push this draft to become law. This is what I think. And now it's critical because, like Dr. Napon said, this draft has been started, what, 2-3 years already? And if we don't proceed today, it might take 20 years.
So thank you, Khun Chamnant. So I think what you have addressed is really important for other countries also, because there are many countries that the construction projects, the construction industry is now very much depend on the government side. So is this legislations, this guideline or this is SOP has something to do with the construction projects, which is funded by the government? And is there any consequences if this legislations has to be also applied to the project which is funded by the government, and at the same time the regulation is also kind of attached to the government? So is that any limitations or any challenges or any worries at all on that part, Neil? And then Dr. Nopon?
Well, I think the introduction of the legislation is probably a complex scenario, in that the legislation, if you've got different governments looking at it, there may be governments that are more pro, say, employer or head contractor, say, and then governments that may be more towards the subcontractor side of things, and maybe they look at cash flow in a different sort of a way. I think one of the keys, though, for the legislation would be to, you're never going to legislate for everything. So to have some sort of an efficient set of legislations that has a relatively clear, robust sort of a procedure. I mean, it's commendable that Thailand is looking to do this, because what I've seen in the industry is, even if you set aside the dispute resolution side of this, which is incredibly powerful for the industry, it's a great optic for the country in respect of its construction industry, particularly internationally, because international companies and international investors want to see a very great, stable industry. But what happens over time, actually, when you go back to your principles of construction management, is a very, very steep increase in skills, because there's a necessity to do things right. So what it actually does is it introduces a standard into industry that many a year ago, we were all taught and we aspired to achieve a certain standard, and that is still true today. There are many great professionals in industry, but it collectively, effectively sets a collective responsibility to do things to a minimum standard, and that minimum standard gradually filters out throughout industry. And that's the sort of promotion that this legislation can also provide. And a government that adopts this and helps to introduce this sort of legislation that's balanced and fair will see, I think, a great increase in not just skill set, but productivity. You'll see lower disputes. You will see a reduction in payment disputes, a reduction in complex disputes at the end of the day, and an industry that increases in productivity. And that increase could be significant, because really, what is the number one problem in industry that stifles progress? And it's cash. So if you can free up the cash in a fair way and raise the skills, the legislation is incredibly powerful.
Thank you, Neil. Dr. Nupon, please.
Yeah.
Is there any other options that this legislation may be having different pathways of adoptions, or maybe incorporation into another regulations or law in Thailand, for example, like PPP law in Thailand? Is that possible at all?
Yeah, I think if we use this law as the act, I think it have to be incorporated with some other related law to, like the buildings, the law of the buildings, conservation, and even on the energy draft, energy act or something like that. So maybe we need to consider some other law, like the labor law and building law, to cooperate with this act too, so that is it not to avoid the conflict between these acts in the future. And but we have already looked at that. Dr. Chunan have already helped us to check this law to avoid confliction as well. Anyway, I myself, I would like to share some point of view of this act in comparison to Australia and some other countries, especially in Australia. You have East Coast, West Coast. You have many acts in your own country. So I have reviewed some an acts of the Victorian Building Authority (VBA). I'm not sure whether you have go through in that or not. I have noticed that for the VBA, for Victorian Building Acts, the process of the claim and the adjudication, mainly they do with the paperwork. They try to avoid to call in person for investigation. Mostly they do it in the paperwork. They submit online. They keep watching on the internet, and that would make the time very short from the submission until the result of the decision. That's what I can see from the good side from the Victorian from the VBA. They apply the communication of the internet. They apply paperwork only. unless the case is complex and large, maybe they do some other way. But in general, they have done by the paperwork. That's why they can make the time, I mean, the processing time very short, like 10 minutes in a day. So they can have, they can know the decision of the claim. And another maybe 15 days, they can know the decision of the adjudication. So altogether, it's this very short time that would meet the objective of this act. But for Thailand, when we discussed it, when I discussed with Dr. Chamran and the team, so it seems that the complexity of the process is have some more constraint on the bureaucratic system that we rely on not only paperwork, but we need to set the person to be in to be decided in person in front of the adjudicator, and they need to submit of many evidence. And this such a long time. So what I can see, this is a major difference between the culture in terms of culture of Thailand and the Australia. But due to the today technology that we can apply, I believe that we can change this. But I'm not sure whether what do you think about recommendation of applying this kind of technology to shorten the time, to shorten the processing time. I mean, in both claim section and the adjudication section too.
Well, there is an interesting point before I move into that part, that with Australia being a federation of states, each state raises its own security of payment legislation. And an interesting concept that the question of, well, how are there any other mechanisms to introduce this legislation? And there is a problem with having several different legislations. And I'm registered as an adjudicator in a number of states, and it takes a long time to really keep up to date with the different legislations and the different way they work. So one concept that has been discussed is, could you introduce this legislation through the Corporations Act? And that's a very interesting topic in Australia, because that's a national act. That's a federal law, and that also captures just commercial. So you automatically lose this sort of private home building side of things. So in terms of introducing legislation, there are many different concepts, and potentially supplementing the Corporations Act with some sort of security of payment process is an interesting concept that's being discussed in Australia at the minute, to circumvent the several different acts that are in place there. But in respect of technology, I think there is no doubt that that's the way to go. So Australia have set up what are called authorised nominating authorities in all states except Queensland, and Queensland state government administer the process itself. And the private authorized nominating authorities have different levels of technology because they're private companies, but they're all generally introducing electronic lodgement. So electronic lodgement of documents, and then they then administer those documents, that application. Now the response, whether that is electronically lodged or not, is just part of the different legislations. But where a party can submit documents electronically, I think is a very good opportunity to really make the process efficient. There are, internet now is such that you can upload very large documentation, and then when an adjudicator is appointed, they receive the documents quickly and then can work through things efficiently. Now, the older adjudicators, or should I say the more experienced adjudicators, tend to like things in paper form, but that's an administrative burden that really I feel they should be able to manage themselves.
Okay, I have another question. Can I, Mr. Wallet?
Please, Ajahn, please.
Okay, I have noticed you mentioned about the ANA, the Australian nomination authority, which is, I mean, this is a separate entity from the for the institutes of the adjudication, right? Yeah. It seems that ANA or for nominating authority we apply throughout the Australian, where you have the different authority for adjudication institutes for each territory. What I can understand that. So I think this is a good concept. When you apply the Australian nominating authority, how could you set up this authority to make sure that you can have a plenty of stock of the people who have plenty or sufficient experience or or qualifications of the adjudicator to put in lines to be sure that the respondents or the claimants can accept or can accept the adjudicator that in nominated. So how can you set up this kind of thing? Because this is very most important thing. If you have only one adjudicator, so that person have to be trusted
Yeah.
by both body.
Well, the legislations generally, except for Queensland, provide for authorized nominating authorities. Now, those authorities are they're responsible for receiving applications, adjudication applications, for training, generally for training adjudicators, and for ensuring that adjudicators are maintain professional development. So the legislation sets out codes of conduct, standards of conduct that both the authorized nominating authority and the adjudicators must comply with, and just general policies and procedures that they have to adopt. And that includes procedures such as appointing adjudicators. So they maintain their own lists of adjudicators, trained adjudicators. There are minimum standards that adjudicators must reach. So in West Australia, I trained many years ago under the old Act. And when they introduced the new legislation, I had to attend and pass new training, which at that time was provided by the government because it was new legislation and they needed some adjudicators already trained before they could introduce the legislation. So that was completed in conjunction with the existing authorized nominating authorities. Okay. And they then had to set about complying with the new legislation and the requirements of that. And there are policies for complaints in the legislation against ANAs, authorized nominating authorities, and a standard of conduct that they have to maintain. I think one of the benefits of that is that authorized nominating authorities that are connected to industry through, say, professional institutions or, learned institutions or universities have got that link with industry and with professionals, and they understand how to conduct training, how to manage professional people, how to maintain professional standards. They've got all of that skill and experience that they can apply to this particular role. And they're impartial in that they have no really involvement in the dispute process other than receiving the application and then appointing an adjudicator. And that appointment of adjudicator is conducted under a procedure that they have to follow as well, a set of guidelines. So you can't have a situation where you have 10 adjudicators on a list and one adjudicator gets 8 appointments and two get 2. You can say, well, why is that?
Right.
So they have a set of standards that they follow, and they're quite rigorous. It's not easy to be an authorized nominating authority, and neither should it be. It should be a high standard, and adjudicators are held to a very high standard as well. And it seems to work quite well. It is probably a little bit more complicated to establish, but once it's established, it frees the wheels and it removes a sort of administrative burden from government. But in return, the authorized nominating authority needs to function financially. So they have a nominating fee and may receive a portion of adjudication fees for training and development
Okay.
purposes.
Okay.
Thank
I have one last
thank you.
point, Mr. Chairman.
Yeah.
Yeah.
Please.
Yeah.
We are now about the time to conclude. So this will be last question from Dr. Nopon, please.
All right. So my last point is on the the enforcement section. So if a decision had already launched, and the claimants need to enforce. So I have seen the concept of the lien concept applied to the enforcement section as well. Can you elaborate more on that, because I'm interested to apply that kind of concept into a Thai Act as well, but I'm not sure whether it's proper, because someone property can be retrained on that upon this law or something like that.
So the Chanman raised this point as well earlier, in that you need a legislation that actually does something,
Yeah.
not just a middle ground that says, well, the adjudicator determines an amount of money, now pay it. But what happens if an employer doesn't pay that money? Well, you have a number of steps. You enforce the determination.
Yep.
In Australia, that enforcement comes very quickly through certificates. So the ANA then issues a certificate. So
Okay.
they have, under the legislation, there is a certification rule for the ANA, the authorized nominating authority, and they issue a certificate that the determination has been made for a certain amount of money. The claimant then goes to court and receives summary judgment, and that must be paid. And that's a very fast process.
All right.
But that can also be challenged, obviously, because then what happens is an employer may raise jurisdictional challenges and say, well, the adjudicator erred and didn't have any power under the legislation to issue that determination. So that's always a complexity. But there are really two aspects. The lien is on the specific work that was adjudicated, but also the right to suspend work is a very powerful right under the Act. So if there is a determination issued and payment isn't made, the claimant has the right to suspend work immediately after provision of a notice. So there are certain things that can be done to really provide the appropriate pressure to make payments happen. And on the whole, that doesn't happen too often. The industry tends to resolve itself. But to have those mechanisms in the legislation is very powerful. But the lien is relatively narrow in that you can't apply it to a third party. It can only be to the work that has not been paid. So you could say of a particular plant or a piece of equipment that was in, well, a lien could be put on that.
Understand. All right.
So there's separate legislation for liens in Australia under the PPA Act that you can apply. So there's separate legislation for liens as well. But the Act itself provides that sort of a lien on the specific work that wasn't paid.
Okay. Thank you. Yep. Very
Thank
good
you.
idea.
Thank you very much. So there are a few questions left, but that we will ask the speakers to address those questions for you, and we will send it to you. May I request Engineer Karim, first Karim, to give the word of thanks to the panelists and speakers. Mr. Karim, please.
Thank you. It was a very nice presentation, I should say. It's my profound gratitude to Mr. Neil, Kirkpatrick, to Achan Nopon and Achan Chamna. It was a very timely and very important issues, not only in Western Australia or Australia and Thailand, but other countries as well. And we have a lot of participants. I think they have got what they wanted. This is a very important and critical issues in many countries in the construction industries, in different construction industries. So I hope that this presentation that we had and the discussions that we had will be very helpful to all of us. And again, I give our gratitude and our thanks to all the speakers, and also to Professor Naro, who has also helped in arranging this program. And I hope that this type of program, we will have it later on also. Thank you very much for all your inputs. Thank you.
Thank you. I hand over to Mr. Farouk to close, please.
Thank you, sir. So thank you, our respected keynote speaker, Mr. Nail, Dr. Nambon, Ajahn Chamnan, Professor Narong, Mr. Fazli Karim Sar, and as well as our moderator and chairman of this panel discussion, Mr. Bharat Chonglasen. So I would also like to thank our production team of our AIT extension who worked behind this today's webinar scenes. So thank you, and thank you all. We hope to meet you again somewhere in some another session. So this is the end of this session. Thank you very much. Goodbye.
Thank you. Thank you. Thank you very much. Goodbye. Thank you, the audience.
Thank you.